Hi, everyone. Welcome to Avalee Law PLLC's Immigration Channel. I'm Avalee, and today we're covering a big topic for H-1B visa holders. How can you stay in the U.S. legally after reaching the 6-year limit on your H-1B visa? The H-1B visa has a strict 6-year cap, but there are ways to continue working and staying legally in the U.S. In this video, I'll introduce you to 4 general strategies to maintain your legal status beyond the H-1B limit. Let's get started. The first option is extending your H-1B status under the AC-21 rule. This allows you to extend your H-1B for either 1 year or 3 years, depending on your situation. 1-year extension. You may qualify for a 1-year H-1B extension under AC-21 Section 106A if your Perm Labor Certification, Form ETA 9089, or your Form I-140 immigrant petition has been pending for at least 365 days. This applies even if your Perm or I-140 has not yet been approved. You can continue to request these 1-year extensions annually until your green card is approved. Next, 3-year extension. You may qualify for a 3-year H-1B extension under AC-21 Section 104C if your I-140 immigrant petition has been approved. Your priority date is not yet current under the Department of State's Visa Bulletin, meaning a green card visa number is not yet available for your category. This 3-year extension is particularly useful for individuals from countries like India or China, where priority dates for employment-based green cards often experience significant backlogs. For example, if you're an IT professional and your I-140 is approved, but your priority date is still 2 years away, you can apply for a 3-year extension to stay employed. The second option is recapturing time spent outside the U.S. during your H-1B period, as allowed under 8 CFR Section 214.2 H-13(3)(c). Here's how it works. Any time you spent outside the U.S. during your H-1B validity doesn't count toward the 6-year limit. For example, if you traveled internationally for 3 months, you can recapture those 3 months and extend your H-1B for the same amount of time. This requires proper documentation, like I-94 travel records and visa stamps, to prove the time you were abroad. If extending your H-1B isn't possible, the third option is to change to another visa status. Here are some common options. H-4 visa. If your spouse is on an H-1B, you can transfer to an H-4 visa. In some cases, you may even qualify for work authorization. O-1 visa. If you have extraordinary ability in your field, the O-1 visa is a great choice. Other visas. You might qualify for employment-based or family-based visa categories, depending on your circumstances. For example, if your spouse holds an active H-1B, you can transfer to an H-4 visa and stay legally in the U.S. while they continue working. Finally, if none of the other options work, you can leave the U.S. for 12 months and reapply for a new H-1B under 8 CFR Section 214.2 H-13(3)(a). Here's how it works. After a 1-year break outside the U.S., you're eligible to enter the H-1B lottery again as a new applicant. This resets your 6-year limit and allows you to start fresh with a new H-1B visa. For example, if you complete your 6 years in H-1B status and return to your home country for 1 year, you can apply for a new H-1B and potentially return to the U.S. for another 6 years. And that's it. 4 general options to maintain legal status after the H-1B 6-year limit. 1. H-1B extensions. 2. Recapturing time outside the U.S. 3. Changing or transferring to another visa status. 4. Reapplying after a 1-year break. While the 6-year limit can be challenging, these strategies can help you stay on the right track. If you have specific questions or need personalized advice, feel free to reach out to our firm. We offer 30 minutes of free consultation and free evaluations for work visa cases. Visit our website to schedule an appointment or submit your case for evaluation. Email us at info@avalola.com. Thank you for watching, and we'll see you in the next video.